Are the first words out of your mouth costing you thousands of dollars? When you get sued by a debt collector, what can you say instead, so that instead of immediately losing the case with the first words out of your mouth, you set yourself up for a total victory? My name is Mike Waslick. I'm one of the lawyers at Ricardo & Waslick here in Florida, and together with my partner Jason Ricardo, when debt collectors give you hell, we help you give it back. We studied over 29,000 debt collection lawsuits, and we've been in the courtroom hundreds of times watching people throw away their chance at a debt collection lawsuit victory by saying the wrong thing from the moment they step up to the podium in the courtroom. Instead of presenting something that might help their case, they cost themselves hundreds, if not thousands of dollars by saying the wrong thing. So today, I'm going to walk you through a small claims debt collection lawsuit. I'm going to tell you the mistakes that too many people make that throws away their chance at victory, and I'm going to tell you what you should say instead to set yourself up for a win. Now, in order to understand the mistakes that people make and what you should do instead, it's important to understand what the small claims debt collection process actually looks like. How do these lawsuits work, and what's the best way for you to come out with a win? First of all, most debt collectors look for easy cases. Debt collectors like Midland, Portfolio, and LV Envy file lawsuits over relatively small amounts of money in small claims court all across the state of Florida. And because those dollar amounts are relatively small, they can't spend a lot of time or money litigating those cases. That's why they look for the easy one. That means that before they file a lawsuit, they look for the ones that they think are going to be the easiest ones for them to collect. And if they think something's going to be too hard or cost them too much money, they might walk away from a lawsuit because it will be too hard for them to collect. Now, there's three ways that they look for those easy wins. First, they try to get people on payment plans, either all up front or for long periods of time for small amounts of money. Next, they try to get people to admit that they owe the debt and that they don't have any defenses. And then third, they count on a significant number of people just not showing up at all and not contesting their debt. Those three things are easy money for debt collectors, and that's exactly the kind of case that they like the most. On the other hand, they hate it when a case turns hard, because maybe a defendant knows what to say and do in the courtroom. And if it looks like a fight, if it looks like it's going to be too hard, there's a good chance they might just drop the case or walk away entirely. Now, the biggest mistake that people make is they put themselves in one of those easy case categories that debt collectors love so much. And they do this in three different ways. First, they fail to show up. I can't tell you how many times I've been in court and seen case after case after case where a defendant has been properly served, they don't show up at all, and the court enters a default judgment against them. This default judgment means that they've lost, and the amount of money the debt collector is claiming becomes a judgment against them, allowing the debt collector to garnish wages, seize bank accounts, and take property without their permission. So if you fail to show up, that means you've lost the case, and suddenly, before you know it, some debt collector is taking a chunk of your paycheck that you can't afford to lose. Now, the second thing that people do wrong is, even if they do show up, they fail to properly deny the debt. When you get called for your case in a small claims debt collection lawsuit, the judge will ask you first if you admit or deny the debt. And if you admit it, you're giving up your legal rights to contest the legal basis and the factual basis for their claims, and you're giving up all of your legal and factual defenses. Basically, it's game over. And then the judge is probably going to send you out to the hallway to discuss, instead of the merits of your case, discuss a payment plan with the other side. So you're entirely giving up your right to fight, and we've seen that happen to hundreds of people in court cases all across the state of Florida. Now, the third thing that people do wrong is they agree to settle the debt by making payments on it. After the judge asks you admit or deny, they're probably going to ask you to have a conversation with the other side about settlement. And in that settlement conversation, the other side is going to try to convince you to make some kind of payment plan, small payments lasting years and years and years, or a big chunk up front. And they love when you do that because it's easy money. Judges love it too, because it means they don't have to spend time presiding over a trial, and it means their workload just got a lot easier. But the only person who shouldn't love it is you, because by agreeing to make payments on a debt, you're giving up all kinds of legal rights to dispute it, and you're probably paying a lot more than you need to. And the worst part is, once you enter into a settlement agreement with a debt collector, you're creating a whole new contract with that debt collector that they now have a right to enforce in the future. And if they didn't have the right to collect before, you've now just given it to them with this new agreement, and they can hold that over your head and squeeze every penny out of it that you've promised to them. So what should you do instead? Well, first of all, show up for your court date. The summons will have a date and a time that you're supposed to appear, and it will tell you if you need to be at a particular place or if you can appear online. When you show up, the judge will ask you if you admit or deny. Tell the judge you deny the debt, or if you feel more comfortable, tell the judge that you want to contest the debt. You just want to make it clear that you're not agreeing to anything. And if you do that, you'll be just fine. Now, sometimes the judge will make you talk to the debt collector's lawyer on that same day to see if you can work out a settlement agreement. And a lot of times you'll be assisted by somebody called a mediator, whose job it is to help the parties reach some kind of settlement agreement if they can. If you get pushed into that position, don't agree on that day to make any payments. You can always change your mind later if you decide to settle. Instead, ask them what evidence they're planning on bringing. Ask them for copies. Bring them home with you and study those. Whatever you do, don't sign any agreements to make payments, and be sure to tell the mediator, if there is one, that you feel there was no agreement on that day. And they will then report back to the judge that the mediation did not reach a settlement agreement. Now, the last thing that will likely happen before you leave is that the judge will want to set the next court date, possibly even a trial date. You'll want to make sure you have your calendar handy so that you can pick a date that works for you. And once you get to the point where the court is setting trial, that's when you have to make a decision. Do you want to keep trying to do this on your own, or do you want to get help going forward? Now, if all of this sounds overwhelming, there's a better way that saves you a lot of time, a lot of stress, and probably even a lot of money. And that's get help from a legal professional. Get help from a lawyer who handle these types of cases on a regular basis. Having a lawyer on the other side makes it hard for the debt collector, and it makes it more and more likely that they're just going to want to pack it up and walk away from the case altogether. Lawyers like us who handle this type of case do it for a lot less money than you're afraid of, and a lot less money than you have to pay if you get tricked into some kind of settlement agreement or miss the court date entirely and get a default judgment against you. And if you get that at the very start, you might not have to go to court at all. Instead of spending hours preparing for a final trial where you may or may not win, you can have the certainty of knowing you're backed by somebody who knows exactly how the case works and the best strategies for making sure you achieve a total victory. Now, most people are afraid of how much it might cost to hire a lawyer to help them out with a situation like this, and usually that's because they've never picked up the phone and actually talked to one. Not only are you likely to save money and stress and the anxiety of standing up in court and trying to argue your own case, but also you're going to save the hours and hours and hours of time it'll take you to prepare for a final hearing or a trial. We've spent the last 30 years learning how to handle cases just like this and get the best possible results for every case we handle. And you can get our experience on your side for a lot less money than you might think. So for debt collection cases in small claims court here in Florida, find out just how reasonable it can be to bring us onto your team. Get a free call with one of our lawyers. Go over the strategy and the pros and cons of your case and figure out whether or not your case is the kind that we can win and save you a ton of money. All you need to do to make an appointment is call the number that's in the description below, and we'll block off a time for you to have your free phone call with one of the lawyers in our firm. So what if you're still thinking of doing this on your own? What if the idea of taking on a debt collector in court on your own excites you? You think you've got the talent, the skills, the abilities to take them on at trial and win? Well, then I want you to watch the video I'm going to put on screen now. It's going to walk you step by step through the most common legal claims that debt collectors make here in Florida, what the evidence they need to prove their case, and most importantly, what you need to do in order to win. So go ahead and watch that video, and thanks for watching this one, and I'll see you on the next one.